Trump unleashed an explosive courtroom confrontation during the January 19th emergency status conference, and that legal observers are calling the most chaotic scene ever witnessed in a federal criminal proceeding. The hearing, which Judge Tanya Chutkan convened to address Trump's lack of legal representation 3 weeks before trial, devolved into what witnesses described as an unprecedented breakdown when Trump insisted on addressing the court directly, despite not being represented by counsel and despite the judge's repeated instructions that he needed to follow courtroom protocols. And this isn't a defendant passionately arguing his innocence or making emotional appeals that occasionally occur during high-stakes criminal proceedings. This is a former president who appeared via secure video link from the federal detention facility in Alexandria, Virginia, launching into extended tirades about prosecutorial misconduct, judicial bias, and political persecution that completely ignored the court's authority, and that resulted in Judge Chutkan threatening to exclude him from his own trial if he continued disrupting proceedings, when a federal judge must consider the extraordinary measure of excluding a defendant from trial proceedings because that defendant refuses to maintain courtroom decorum. It represents a complete breakdown of the normal adversarial process and creates constitutional complications that have no clear resolution. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what exactly happened during the January 19th hearing that transformed a routine status conference into an explosive confrontation that has left the entire federal prosecution in unprecedented territory? According to multiple sources who attended the hearing, the chaos began immediately when Judge Chutkan opened the proceedings by addressing Trump's lack of legal representation following Christopher Keese's withdrawal. The judge explained that the purpose of the conference was to determine whether Trump had secured new counsel, whether he intended to represent himself, or whether he wanted the court to appoint standby counsel to assist him. Before the judge could finish outlining these options, Trump interrupted via the video link and began speaking directly to Judge Chutkan in what witnesses described as an aggressive and confrontational tone. Sources in the courtroom reported that Trump stated he wanted to address what he called the rigged nature of the entire proceeding and the corrupt judge who had already demonstrated bias by detaining him illegally. Judge Chutkan immediately instructed Trump to stop speaking and explained that defendants appearing without counsel must still follow courtroom procedures and cannot simply interrupt the court whenever they choose. The judge stated that if Trump wished to represent himself, she would need to conduct a formal inquiry to ensure he understood the risks of self-representation and was knowingly waiving his right to counsel, but that this inquiry required Trump to answer specific questions rather than delivering speeches about the case. Trump reportedly responded by stating that he refused to participate in what he characterized as a show trial and that the American people deserved to hear the truth about the political persecution he was facing. The former president launched into what witnesses described as a several-minute monologue about the 2020 election, about what he claimed was a conspiracy to prevent him from returning to power, and about Judge Chutkan's alleged bias as demonstrated by her rulings throughout the case. The judge repeatedly instructed Trump to stop speaking and warned that if he continued to disrupt the proceedings, she would mute his audio feed and proceed without his participation. This initial confrontation set the tone for what became a 3-hour hearing that legal analysts are describing as unlike anything previously seen in federal criminal practice. Judge Chutkan attempted multiple times to conduct a structured inquiry into whether Trump understood his right to counsel and whether he was competently waiving that right. However, each time the judge asked a specific question, Trump either ignored it entirely and continued discussing his grievances about the prosecution, or gave answers that suggested he fundamentally misunderstood the nature of the proceedings and believed he could use the hearing as a platform for political messaging rather than as a legal proceeding focused on narrow questions about representation. Smash that like button if this is making sense so far. The most dramatic moment in the hearing came approximately 90 minutes into the proceeding when federal prosecutors asked Judge Chutkan to make findings about whether Trump was competent to waive counsel and represent himself, given his apparent inability or unwillingness to follow basic courtroom protocols. Assistant U.S. Attorney Molly Gaston argued that the constitutional right to self-representation exists only when defendants can conduct themselves appropriately in court and can present a defense within the framework of legal procedures and evidentiary rules. Gaston stated that Trump's behavior during the hearing demonstrated that he either did not understand or deliberately refused to accept the constraints that apply to all trial participants, and that allowing him to represent himself would create chaos that would make it impossible to conduct orderly proceedings. Trump responded to this argument by stating that prosecutors were afraid of what he would reveal if allowed to represent himself and cross-examine government witnesses. He claimed that his questioning of witnesses would expose the entire conspiracy to rig the 2020 election and to weaponize the justice system against him. Trump stated that the prosecution wanted to silence him by forcing him to accept attorneys who would prevent him from presenting his real defense, which he characterized as proving that the charges against him were part of a broader plot to prevent him from returning to the presidency. Judge Chutkan then attempted to explain to Trump the difference between legal defenses that focus on whether the government can prove the elements of charged offenses and political arguments about the motivations behind prosecution. The judge stated that criminal trials are not forums for defendants to advance broad political narratives, but rather are proceedings focused on narrow legal questions about whether specific evidence proves that defendants violated particular criminal statutes. Judge Chutkan explained that if Trump chose to represent himself, he would need to confine his arguments to legally relevant issues and could not use cross-examination of witnesses or opening and closing statements to discuss election fraud claims or prosecutorial bias unless those topics were directly relevant to the charged offenses. Trump's response to this explanation reportedly demonstrated the fundamental disconnect that makes self-representation unworkable in this case. According to sources, Trump stated that the judge's restrictions on what he could discuss proved the trial was rigged because he was being prevented from presenting his real defense. He argued that the charges against him were inseparable from the question of whether the 2020 election was stolen and whether prosecutors were acting on political rather than legal grounds. Trump stated that preventing him from discussing these issues was denying him the right to defend himself and was further evidence of the corrupt nature of the proceedings. This exchange crystallized the impossible situation that Judge Chutkan faces. Trump appears determined to use any trial as a platform for political messaging about election fraud and prosecutorial bias, rather than as a forum for presenting legal defenses to the specific charges. However, criminal trials cannot function if defendants are allowed to disregard evidentiary rules and ignore relevance requirements and turn proceedings into political rallies. The judge must somehow reconcile Trump's constitutional right to represent himself with the court's obligation to maintain orderly proceedings and to ensure that trials focus on legally relevant issues rather than devolving into chaos. Drop a comment right now if you saw this coming. I read every single one. Judge Chutkan eventually recessed the hearing after determining that no productive resolution could be reached during the conference, and before recessing, the judge made several critical rulings that established the framework for how the case will proceed. First, Judge Chutkan ruled that she would appoint standby counsel from the Federal Public Defender's Office to be available to assist Trump, regardless of whether he wanted such assistance. The judge emphasized that this appointment was being made to protect Trump's constitutional rights and to ensure that he had access to professional legal advice, even if he chose to represent himself at trial. Second, the judge ruled that she would grant a 2-week continuance of the trial date, moving it from February 10th to February 24th. Judge Chutkan stated that this limited continuance would give Trump additional time to secure private counsel if he chose to do so, and would give appointed standby counsel time to review the case and prepare to assist. However, the judge made clear that this would be the final continuance and that the case would proceed to trial on February 24th, regardless of whether Trump had retained private attorneys by that date. Third, and most controversially, Judge Chutkan ruled that if Trump continued to disrupt proceedings through outbursts, refusal to follow courtroom protocols, or attempts to turn the trial into a political platform, she would exercise her authority to exclude him from the courtroom and allow the trial to proceed in his absence. The judge cited legal precedent holding that defendants who engage in disruptive behavior can forfeit their right to be present at trial after being warned that continued disruption will result in exclusion. Judge Chutkan emphasized that she hoped this measure would not be necessary, but that she would not allow Trump's behavior to prevent the trial from proceeding in an orderly manner. This threat to potentially exclude Trump from his own trial represents an extraordinary assertion of judicial authority that will almost certainly be challenged on appeal if Judge Chutkan actually follows through. The Sixth Amendment guarantees defendants the right to be present at their trials, and courts have held that this right is fundamental to ensuring fair proceedings. However, the Supreme Court has also recognized that defendants can forfeit their presence right through persistently disruptive behavior that makes orderly trial proceedings impossible. The question of whether Trump's conduct rises to the level that would justify exclusion will likely be litigated extensively if Judge Chutkan actually excludes him from any portion of the trial. The legal standards governing a defendant's right to be present at trial and the circumstances under which that right can be forfeited are complex and have been developed through decades of case law. The Supreme Court's decision in Illinois v. Allen established that defendants who engage in conduct so disruptive that orderly trial proceedings become impossible can be excluded from the courtroom after being warned that continued disruption will result in removal. However, courts must use exclusion as a last resort after attempting less severe measures such as warnings, contempt, and sanctions or physical restraints if the disruption involves violent behavior. Judge Chutkan's ruling that she may exclude Trump if he continues disrupting proceedings suggests she has concluded that warnings alone may not be sufficient to ensure orderly trial conduct. The judge's threat appears designed to put Trump on notice that his behavior during the January 19th hearing was unacceptable and that similar conduct during trial will not be tolerated. However, actually excluding a former president from his own criminal trial would create unprecedented constitutional and political complications that extend far beyond the narrow legal question of whether exclusion is permissible under Illinois v. Allen. The appointment of standby counsel from the Federal Public Defender's Office creates its own complications and raises questions about how this arrangement will function in practice. Standby counsel are attorneys appointed to assist defendants who choose to represent themselves, providing legal advice and potentially taking over representation if the defendant becomes unable to continue pro se representation. However, standby counsel cannot direct the defense strategy if the defendant insists on maintaining control, and they cannot prevent defendants from making strategic decisions that counsel believes are unwise. The federal public defender appointed as Trump's standby counsel will face an extraordinarily difficult professional situation. On one hand, the attorney has ethical obligations to provide competent legal advice and to assist Trump in this presenting the most effective defense possible. On the other hand, Trump has made clear through his statements during the January 19th hearing that he intends to pursue a defense focused on political narratives rather than conventional legal arguments, and that he views anyone who tries to constrain his approach as part of the conspiracy against him. Standby counsel who attempts to provide guidance that Trump rejects or who tries to prevent Trump from making statements that counsel believes are legally harmful may be caught between professional obligations and a client who refuses to accept professional judgment. Legal ethics experts who have analyzed the standby counsel appointment emphasize that these arrangements work best when defendants respect their standby counsel's expertise and are willing to accept guidance even while maintaining ultimate control over strategy. The January 19th hearing suggests that Trump has no intention of accepting such guidance and views any attempt to constrain his approach as evidence of bias or conspiracy. This makes it unlikely that standby counsel will be able to function effectively in the traditional sense, though the appointment may still serve the important purpose of providing Trump with access to professional legal advice and ensuring that appellate courts cannot conclude he was completely denied assistance of counsel. The two-week trial continuance from February 10th to February 24th represents Judge Chutkan's attempt to balance Trump's need for time to secure representation against the court's determination not to allow indefinite delay. 2 weeks is a very limited period for new attorneys to get up to speed on a complex federal criminal case, and the continuance appears designed more to demonstrate that Trump was given a reasonable opportunity to find counsel, rather than to provide genuinely adequate preparation time. If Trump does manage to convince new attorneys to join his defense during this 2-week period, those attorneys will face enormous pressure to prepare for trial on a compressed timeline while also managing a client who has demonstrated he does not follow legal advice. However, the limited continuance makes clear that Judge Chutkan will not allow the case to be delayed indefinitely based on Trump's inability to secure willing counsel. The judge's ruling that trial will proceed on February 24th, regardless of whether Trump has retained private attorneys by that date, signals her determination to bring the case to trial within a reasonable time frame. And this approach reflects judicial judgment that Trump's lack of representation results from his own conduct and choices rather than from systemic barriers, and that further delay would reward behavior that has made representation impossible. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. The political and media reaction to the January 19th hearing has been intensely polarized, with dramatically different interpretations of what the courtroom confrontation reveals about the prosecution and about Trump's situation. Trump supporters and conservative media outlets have portrayed the hearing as confirming that the trial is a rigged political prosecution, where Trump is being denied the ability to defend himself and where the judge is demonstrating obvious bias. Social media platforms exploded with posts claiming that Judge Chutkan's threat to exclude Trump from his own trial proves the entire proceeding is a show trial designed to silence him and prevent him from exposing the truth about the stolen election. However, legal analysts and former prosecutors have offered very different assessments, emphasizing that Trump's behavior during the hearing demonstrated exactly why self-representation would be disastrous and why judges must maintain authority. To control courtroom proceedings, Barbara McQuaid, former U.S. attorney and University of Michigan law professor, noted that criminal trials require adherence to rules of evidence and procedure, and that defendants who refuse to accept those constraints cannot effectively represent themselves regardless of their intelligence or communication skills. McQuaid stated that Judge Chutkan's handling of the hearing was appropriate, and that the threat of exclusion was a necessary response to Trump's persistent disruption. Former federal prosecutor Renato Mariotti emphasized that the courtroom is not a political rally and the judges have legitimate authority to prevent defendants from using trials as platforms for grievances unrelated to the specific charges. Mariotti noted that Trump's insistence on discussing election fraud and prosecutorial bias rather than focusing on whether the government can prove the elements of the charged offenses demonstrates a fundamental misunderstanding of how criminal trials function. He stated that allowing Trump to represent himself would create chaos and would make it virtually impossible to conduct orderly proceedings. The question of what happens next in Trump's courtroom drama depends on several variables that will play out over the next 2 weeks before the February 24th trial date. First, it remains possible, though unlikely, that Trump could convince new private attorneys to take his case during the continuance period. Any attorneys considering such representation must evaluate whether they can work with a client who has demonstrated he will not follow legal advice, who insists on political defense strategies that counsel may view as legally irrelevant, and who is detained in federal custody with limited access for attorney meetings. Second, Trump must decide whether to accept the assistance of appointed standby counsel or whether to insist on proceeding completely pro se without any professional legal support. While Trump's statements during the January 19th hearing suggest he views appointed counsel as part of the system conspiring against him, the practical realities of representing oneself in a complex federal criminal trial may convince him that some professional assistance is preferable to having no legal support at all. Third, the D.C. Circuit Court of Appeals must rule on Trump's pending appeal of his detention order. If the circuit reverses Judge Chutkan's detention decision and releases Trump under modified conditions, it would eliminate some logistical barriers to attorney access and trial preparation. However, given that the D.C. Circuit has not ruled despite the emergency nature of the appeal and despite the passage of several days since Trump was detained, observers are beginning to speculate that the court may be inclined to affirm the detention order or may be struggling with how to address the unprecedented nature of detaining a former president. Don't go anywhere. And the most critical analysis of where this case goes from here is coming next. The constitutional implications of Trump proceeding to trial either pro se or with only standby counsel he refuses to cooperate with are profound and will almost certainly generate extensive appellate litigation regardless of the trial's outcome. The Sixth Amendment guarantees defendants the right to assistance of counsel in criminal prosecutions, and while this right can be waived, courts must ensure that waivers are knowing and voluntary. If Trump's waiver of counsel results from his inability to find willing attorneys due to his own conduct, appellate courts will need to determine whether that constitutes a valid waiver or whether it represents a constructive denial of his constitutional right to representation. The Supreme Court addressed related issues in Ferretta v. California, holding that defendants have a constitutional right to represent themselves if they knowingly and intelligently waive counsel. However, Ferretta also emphasized that courts can require defendants who choose self-representation to comply with courtroom rules and procedures, and that the right of self-representation does not include the right to disrupt proceedings or to disregard evidentiary requirements. The tension between these principles becomes acute in Trump's case, where his apparent determination to use trial as a political platform conflicts fundamentally with the procedural constraints that Ferretta contemplates. If Trump proceeds to trial representing himself and is ultimately convicted, appellate courts will face difficult questions about whether his Sixth Amendment rights were adequately protected. On one hand, Trump was offered appointed counsel and chose to reject that assistance, suggesting any deprivation of counsel was voluntary. On the other hand, if Trump's rejection of counsel resulted from a fundamental misunderstanding about what role counsel would play or from an inability to appreciate that political defenses are legally irrelevant, appellate courts might conclude his waiver was not knowing and intelligent as Ferretta requires. Similarly, if Judge Chutkan excludes Trump from portions of his trial due to disruptive behavior, appellate review will need to determine whether the disruption was sufficiently severe to justify exclusion and whether the judge provided adequate warnings and attempted less restrictive alternatives before resorting to exclusion. The Illinois v. Allen standard requires that exclusion be used as a last resort. But determining what constitutes a last resort in the context of a defendant who persistently attempts to turn trial proceedings into political theater involves subjective judgments that appellate courts may second guess. The practical question of how trial will actually proceed if Trump represents himself raises numerous concerns that go beyond abstract constitutional principles. Federal criminal trials are highly structured proceedings governed by complex rules of evidence and procedure. Self-represented defendants must make objections to evidence in real time, must cross-examine witnesses effectively, must present coherent legal arguments about whether the government has met its burden of proof and must navigate numerous procedural requirements that trip up even experienced attorneys. Trump has no legal training and has demonstrated through his public statements and his conduct during the January 19th hearing that he does not understand the distinction between legal relevance and political significance. His cross-examination of government witnesses would likely focus on whether they are part of the conspiracy against him rather than on whether their testimony actually proves the elements of the charged offenses. His opening statement would probably address election fraud and prosecutorial bias rather than previewing evidence that challenges the government's case. His closing argument would almost certainly emphasize political grievances rather than reasonable doubt about specific factual elements. All of this would be legally ineffective and would give the government an enormous advantage at trial. Federal prosecutors would face a defendant who is inadvertently helping them prove their case by focusing on irrelevant issues while failing to challenge the actual evidence against him. The result would likely be a swift conviction that could have been avoided if Trump had competent counsel presenting conventional legal defenses based on challenging witness credibility, disputing intent, and arguing that his conduct did not meet the statutory elements of the charged offenses. The appointment of standby counsel provides some mitigation of these problems if Trump is willing to accept guidance, but the January 19th hearing suggests he views such guidance as illegitimate constraint rather than professional assistance. Standby counsel can whisper suggestions to Trump about objections he should make or questions he should ask, but cannot force Trump to follow that advice. If Trump ignores standby counsel's suggestions and pursues his preferred approach of political advocacy rather than legal defense, the result will be essentially the same as if he had no counsel at all. Looking ahead to the February 24th trial date, several scenarios are possible depending on decisions Trump makes during the 2-week continuance period. The best case scenario from a fair trial perspective would be that Trump convinces qualified private attorneys to take his case and that those attorneys can prepare adequately in the limited time available. However, this scenario appears extremely unlikely, given that experienced criminal defense attorneys have consistently declined to represent Trump under current circumstances, and given the compressed timeline, a more likely scenario is that Trump proceeds to trial either completely pro se or with appointed standby counsel that he largely ignores. Under this scenario, trial would begin on February 24th with Trump attempting to represent himself while standby counsel provides whatever assistance Trump will accept. Judge Chutkan would need to manage the proceedings carefully to protect Trump's constitutional rights while also maintaining order and ensuring that the trial focuses on legally relevant issues. The judge would likely need to intervene frequently to prevent Trump from asking irrelevant questions, making improper arguments, or disrupting proceedings, and each intervention would create potential grounds for appeal. A third possibility is that Trump's disruptive behavior during trial leads Judge Chutkan to exclude him from the courtroom as she threatened during the January 19th hearing. This would create the extraordinary spectacle of a former president's criminal trial proceeding in his absence, with standby counsel presenting whatever defense they can construct while Trump is excluded due to his own conduct. Such an outcome would generate enormous political controversy and would almost certainly result in appellate challenges to the conviction based on violation of Trump's right to be present at trial. Drop a comment below with your thoughts, and I'm genuinely curious to see your perspective. The ultimate significance of the January 19th courtroom meltdown extends beyond the immediate question of how Trump's trial will proceed to broader issues about the criminal justice system's capacity to handle defendants who refuse to accept the constraints that allow adversarial proceedings to function. The system assumes that defendants will work cooperatively with their attorneys, will accept courtroom rules and procedures, and will focus their defenses on legally relevant arguments about whether the government has proven its case. When defendants reject these basic premises and insist on treating trials as political theater, the system struggles to respond in ways that protect constitutional rights while also ensuring orderly proceedings. Trump's case presents these challenges in their most extreme form. Because of his former position, his continued political activities, his enormous public platform, and his determination to use legal proceedings as opportunities for political messaging. The collision between Trump's approach and the requirements of orderly criminal proceedings has already resulted in the detention of a former president, the removal and withdrawal of all his attorneys, and threats of exclusion from his own trial. These extraordinary measures reflect judicial determination to maintain control of proceedings, but they also create constitutional complications and political controversies that will persist regardless of the trial's outcome. If this blows your mind, hit that like button right now. The January 19th hearing demonstrated that no easy resolution exists to the crisis created by Trump's loss of all legal representation and by his determination to use trial as a platform for political advocacy rather than as a forum for legal defense. Judge Chutkan's rulings appointing standby counsel, granting a limited continuance, and threatening exclusion for disruptive behavior represent her attempt to balance competing interests and to create a framework that protects constitutional rights while allowing trial to proceed. However, the underlying tensions that created this crisis persist and will likely manifest throughout trial proceedings if Trump continues his confrontational approach. The 2 weeks between the January 19th hearing and the February 24th trial date will determine whether any resolution can be found that allows the trial to proceed in a manner that both protects Trump's constitutional rights and maintains the integrity of judicial proceedings. Trump must decide whether to continue insisting on representing himself or whether to accept the assistance of standby counsel. Potential private attorneys must decide whether the professional risks of representing Trump under these circumstances can be managed. Judge Chutkan must prepare to conduct a trial under unprecedented conditions involving a detained former president who may be representing himself and who has demonstrated he will not follow normal courtroom protocols. The stakes involve not only Trump's liberty and his right to a fair trial, but also fundamental questions about whether the criminal justice system can successfully prosecute high-profile defendants who view legal proceedings as political warfare and who refuse to accept the procedural constraints that allow adversarial trials to function fairly. The answers will emerge as trial approaches and as the various actors in this courtroom drama make final decisions about how to proceed. Keep extremely close watch on developments over the next 2 weeks as the February 24th trial date approaches. Trump may attempt to recruit new private counsel, though prospects appear dim given consistent rejections by auto-qualified attorneys. The D.C. Circuit may finally rule on Trump's detention appeal, potentially changing the logistical circumstances, though not the underlying conflicts about trial strategy and courtroom conduct. Judge Chutkan may need to issue additional rulings clarifying the role of standby counsel and the consequences if Trump continues disruptive behavior. The resolution of these issues will determine how one of the most significant criminal trials in American history actually proceeds when it begins on February 24th. Before we go any further, smash that subscribe button so you never miss content like this. The explosive January 19th hearing revealed the complete breakdown of normal adversarial criminal proceedings in Trump's federal election interference case. A former president appeared via video link from federal detention and engaged in persistent confrontations with the judge, refused to follow courtroom protocols, and insisted on discussing political grievances rather than addressing narrow questions about legal representation. Judge Chutkan responded by appointing standby counsel, granting a 2-week trial continuance to February 24th, and threatening to exclude Trump from his own trial if he continues disruptive behavior. The courtroom meltdown demonstrated the profound challenges of prosecuting a defendant who views criminal proceedings as political persecution and who refuses to accept the constraints necessary for orderly trials. What happens next depends on decisions Trump makes about representation and courtroom conduct over the coming 2 weeks. But the underlying conflicts that created this crisis show no signs of resolution. The trial is now set for February 24th, and the legal, constitutional, and political dramas will only intensify as that date approaches. Pause for a second and hit that like button if you're finding value in this coverage.